right, welcome to Law&Crime. We're going to take a little bit of a diversion here and give you an update in a murder case of 20-year-old nursing student Holly Bobo, whose remains were found 3 years after she went missing back in 2011. Now, a jury convicted Zach Adams for her murder, largely in part due to testimony from a co-defendant, Jason Autry, who took a plea deal in order to testify. Now, he is allegedly recanting his testimony. If you do not remember the case of Holly Bobo, she disappeared from her home in 2011 with her remains discovered not too far from her home. Her cause of death was determined to be a fatal gunshot wound to her head. Now, no DNA evidence linked the defendant, Zach Adams, to the crime. His brother, Dylan Adams, was also arrested and took an Alford plea for aggravated murder and kidnapping charges. Okay, so let's take a look a little bit more here, guys, into this case. And I'm going to start, Jeffrey, with you. What do you make of this now alleged recantation many years later? What is the process that's followed? And is this a serious possibility of reversing this conviction?
I don't make much of it because recanting by witnesses years post-conviction are typically treated as unreliable unless there is new evidence which would explain why the witness is recanting. In other words, new evidence emerges, for example, that his testimony was coerced by the police or by the prosecuting attorney. Absent that, I don't think it'll go very far.
Yeah, I'll tell you, as a prosecutor, Megan, whenever I use co-defendants, I always did it with this very skittish feeling, because you know that phrase, when you sleep with dogs, you can catch fleas. And sometimes people can be very convincing witnesses, especially when they're incentivized to testify for the government because they're going to get a benefit. And I don't disagree. You want corroborating evidence, but I don't know. Does it come down to sometimes just gauging the credibility of the person and them saying I lied? Because this could be a substantial basis, not just that the person's not guilty, but they may be innocent. What do you think?
Yeah, I think you hit the issue right on the head. This is a cooperating witness with the government who has an incentive to testify on the government's behalf. They're going to get some sort of deal out of the equation. And so that likely was raised by the defense at trial. You can't trust the credibility of the cooperating witness. But now we've got that already shaky credibility really shot if this witness is recanting their testimonies, admitting that they lied at the trial. Now that, in combination with the true lack of physical evidence in this case, I think at least deserves an evidentiary hearing to assess what was done in the interrogation of the cooperating witness, what other information potentially can come to light if there was any prosecutorial misconduct. We don't hope for that. Certainly, we hope that everything was done on the up and up. But when somebody's liberty is at stake, I think this deserves another look, and it's a valid basis for an appeal.
Jeffrey, I know it may sound counterintuitive to many in the audience, but I believe, or at least I believe my obligation when I was a prosecutor, something like this came up. And to Megan's point, this was a very thin case factually. And the testimony of this now recanting witness was a substantial, I don't think anybody can deny that, factor that led to the conviction of the defendant. Now, of course, I don't want somebody to get off for something after we put all that hard work in, but it is true. There are things that get done when you're doing a cooperating witness that don't necessarily always make it to paper, or the feel of it doesn't really get in there. The pressure tactics that are used may not be in the antiseptic report that's written by the detectives, and all sorts of things that I could tell you I've seen in my experience. So I do believe, I think the first stop to this, in my opinion, where I've seen the biggest injustices occur, is having a prosecutor who will keep an open mind about the fact and work with the presumption that maybe he is innocent and then work backwards. I need to be convinced as a prosecutor that my conviction is 100% unassailable. Otherwise, I'd rather let the defendant go than to continue to have him incarcerated. But my feeling is, and I'll toss it to you after this, Jeffrey, is that unfortunately most prosecutors aren't thinking with this mentality. They're thinking with the mentality, win at all costs.
Our legal system is set up with a high burden for criminal jeopardy. There's the old adage you're familiar with, better that 10 guilty go free than one innocent be convicted. And it's absolutely true, and Megan hit right on it, which is this deserves hearing. It deserves to be briefed. What is the basis for this alleged recanting of the story? But of course, the credibility of this witness will be directly at issue, and he has changed his story many times. He told a television station that he had nothing to do with the disposing of the body, then took a plea and testified only to that purpose, and that the real murderer is the defendant, Zach Adams, who's now in jail. And now he's got a third version, which is that he lied and Zach Adams is innocent. So I think at the end of the day, his credibility will be important in how this comes down.
Yeah, well, I just like to say that, you know, if this witness had been somebody that came to the prosecutors having before the trial said one thing, during the trial said another thing, after the trial said another thing, that's the definition of a non-credible person. And my point is before it has to go to litigation and have a judge make a decision, the prosecutor has the power to use their office to do the right thing. Okay, Megan, I want to thank you very much. Great job for everything. We're going to take a quick break. We'll be right back. Please stay with us. Welcome to the Law and Crime Trial Network. If you're just joining us, my name is Bob Bianchi. We are in our second of 3 hours of live coverage, and we're going to take a little turn now to the twisty and never-ending saga of Alex Murdaugh's bid for a new trial now that has been denied following an evidentiary hearing on allegations that a court clerk tampered with the jury during their deliberations. South Carolina Supreme Court Justice Jean Toll made her ruling after hearing testimony from the 12 original jurors in Murdaugh's trial, as well as testimony from Colton County Clerk of Court Rebecca Hill. That's the individual who supposedly was interfering with the jury. Murdaugh's defense was allegedly in their retrial bid saying that Hill had made improper contact with the jury during the trial and that influenced the outcome of the trial. Now, as you all know, a judge is always telling a jury not to have any contact or any outside influences and only to judge the case specifically, solely, and only upon the facts adduced during the trial, the witnesses that were presented during the trial, and the arguments of counsel and the rulings of the court. And the judge will also instruct if anyone attempts to try to contact you outside those parameters, you're to immediately notify the court. Why? Because we want to have a fair trial and we want to make sure the jurors are not tainted. Well, Justice Toll ruled that while Hill was not completely credible as a witness, that's the court clerk, she did not believe that the jurors were persuaded by any remarks she may have made. Wow. May not have been persuaded. Hill denied the allegations that she ever conversed with jurors about the case during the trial. Again, the judge not finding that wholly credible. Alex Murdaugh was convicted in 2021 for the murders of his wife Maggie and son Paul. He's currently serving a life sentence as well as 27 years in prison for financial crimes that he had pled guilty to. Look, not a sympathetic guy, but this is about due process. This is about justice. This is about how our court system operates, regardless of whether you're good, bad, or ugly. Let's take a listen now to the ruling from Justice Jean Toll, because I have to tell you, there's a lot of legal scholars and a lot of legal experts that are kind of surprised by what they heard.
The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned. I have probably had more experience with trial and appellate work than anyone else in this room for many years, and it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
I'm trying to let my blood pressure just like drop down a little bit. Well, I got Jeffrey Simon still with me. He's a trial attorney. Now with us is Bridget Williams, trial attorney, former prosecutor. Jeffrey, I'm going to you because I know that you know Judge Jean Toll, and I noticed that she was standing up at the end of the proceeding, and I was just wondering, maybe her foot may have been throbbing because she kicked that big can down the road to the appellate division with such ferocity and such like vigor that she may have actually sprained her entire foot in doing it. I mean, honestly, she makes a great appearance. She looks very judgely or whatever. So our audience can know, you can disagree with me. I'm hot about this. This was so filled with garbage, which she just said. There was a juror who indicated that they were influenced by this. This is an outrageous abridgment. This isn't just somebody who came in because they wanted fame and that they were seeking status. This was a court clerk. This was a court official. This person has more authority next to anyone other than the judge that came in. And it doesn't make a difference if you think it may have or whatever. It impinged the process that the judiciary set up themselves to make sure that there would be fair and impartial jurors. And juror, at least one, indicated it did influence their decision. So she didn't want to make that ruling either. And then when she just saw our audience, I was like, I gotta get it out off my chest. Oh, well, let the higher authorities make the decision. That's not the way it works. That's not the way it works. The higher authorities are going to defer to her credibility findings because the credibility findings of the judge below are rarely disturbed. So when she makes a credibility finding that she doesn't believe it influenced the jury, that's going to be very hard for an appellate court to overrule. I think that this was I'm outraged not for Murdoch. Okay, I'm outraged as a prosecutor who's had to deal with issues where there's potential jury tampering, nowhere near anything like this, where I had to literally say, you know what, a new trial is warranted here for the preservation of our process. I'm sorry, my rant's over. I can't believe what I just saw there. I can't.
Well, Judge Toll is one of the most respected and arguably most well-known judges in South Carolina. And you are absolutely right that she is likely to receive deference at the appellate courts in South Carolina, both because of who she is and also because there is a legal standard where, they're not starting what we say de novo at the appellate courts. They're going to be beginning with a presumption that she got the ruling right, that otherwise she would have had to abuse her discretion to overturn it. Now, having said that, I agree with you that there does have a certain feel in what she said, like, well, they framed a guilty man. We all know he's guilty, right? There is some element of that there, and I don't know why she went to that length other than to say, well, I believe the jurors were not influenced by this court clerk who undeniably acted improperly because the evidence was so overwhelming against the defendant. And I agree that there are reasons to be indignant about that.
Yeah, but Bridget, I come from a different place, and I come from a place where that jury box is sacrosanct. And if there's even somebody sneezes the wrong way, they are bringing them in and voir diring them. And there is to be a penalty if something is done, even if it may not have substantially influenced. It doesn't make a difference so long as it influenced at all or had the capacity to influence. And another judge, for example, a Judge Bianchi, could sit there and say, you cannot tell me when an officer of the court comes into a jury room and starts besmirching, belittling, humiliating the defendant, you cannot tell me, no matter what the words they say, that it wouldn't have influenced them. Now, we know one juror did, and one juror is all it takes to get a hung jury or a not guilty verdict, or at least certainly not a guilty verdict. And you know as well as I do, my last part of the rant, I love these questions. Well, would that have affected your ability to be fair and impartial and not follow the instructions and listen to the evidence that the instructions we gave? They should only do it based on the evidence. Oh no, Judge, I can do that. Jurors do not want to come out and say that. We have to use our common sense here. I'm sorry, this is just wrong to me. And you know what? And is this court clerk going to be charged with any official misconduct or any kind of crime for this? I mean, this is like, I'm no Alec Murdoch fan by any stretch of the imagination, both as a lawyer, a fraud, a murderer, whatever he may be, but he does have a right. We have a right. The citizens have the right. The viewers of the Law&Crime Network have a right to have a fair trial.
Yes. Yes to all of that, Bob. All of that. One of the things that stood out to me from Judge Toll, what she stated here, she said that despite the court clerks making a fleeting and futile comments, that was not enough, in order to sway someone's verdict. But like you stated, even if there is one thing that is said from an outside person or something that influences a juror outside of whether the evidence is presented in the trial, and that juror member comes forward and says, well, this influenced my verdict in some way, that is enough. That is enough on its own in order to provide a new trial. And she is pretty much adamant that that is not enough in order to move forward with the new trial. And like you stated before, she's pushing that off to the appellate court to handle. And I mean, I'm blown away with her response in that, okay, well, they convicted someone that is a guilty person. Well, that person that was persuaded by the comments of this court clerk, they may not have agreed to vote for guilty if they had not heard from that court clerk. We will never know. We will never know. And so she doesn't give merit to that juror in order to provide them the court now with the stance that says, okay, well, we will honor our judicial system by moving forward with a new trial in this case. It's ridiculous.
Yeah, I know as a prosecutor, I don't want to try a second case, but I'm telling you as a prosecutor, if this had happened to me, I would have been concerned about the propriety of the verdict itself. And I would have been in a very torn state as to whether I was going to argue it if I was convinced that jurors were spoken to by a judicial clerk. Hey, guys, I guess the bottom line is this. Let's not let justice and the justice system get in the way of a good conviction. We're going to take a break. We'll be right back.